Recently, the Supreme Court of Canada did something quite unusual. They reviewed the solely religious decision of a church community. Courts have traditionally shied away from getting involved in religious disputes. Now, Barry Bussey is the Director of Legal Affairs at the Canadian Council of Christian Charities, and he joins us now from Elmira, Ontario. How are you, Barry?
I'm doing fine. How about yourself?
Doing really well, thank you. So the lower courts ruled that, yes, a court of law can judicially review a decision made by a religious community.
Well, I tell you, that's in essence what happened. What happened was that Mr. Wall, Randy Wall, got into a dispute with his local congregation, a Jehovah's Witness congregation, and he was involved in some drinking and so forth. And anyhow, they decided that he was to leave the congregation. He then, what he wanted to do was go to the court and ask the court to, he said, judicially review the decision of the church. Now, the problem with that is that a judicial review generally is when a court looks at a decision maker, but a public decision maker, like a government actor, a labor relations board decision or something like that. And then the court would say, okay, whether or not the decision maker followed the rules in ensuring that there was fairness and that kind of thing. So immediately when he went through the grounds of appeal within the church, he was denied. Then he took it to the secular courts. And the secular court in the first instance looked at it and said, well, you know, normally courts don't get involved in this unless there is an issue of contract rights or property rights. And the judge looked at it and said, well, because as a real estate agent, you normally would have your clients coming from church members, and now that you're no longer a church member, those regular friends of yours from church are no longer doing business with you. Well, that's a property right, or that's a property issue that would need to be determined. And so on that basis, the court said, well, okay, we should be able to look at this decision. Now, that was quite something, because when you think about it for a minute, the church didn't tell Mr. Wall that he was to keep his business only with church members. That was up to him. That was his decision. And, you know, that's natural after many years of being in that church. He was like over 20 years members of that church. So you can understand how your relationships would form and that kind of thing. But because you leave a church, or because the church asks you to leave and then people don't do business with you, that's not the church's fault. That is a risk that you took as a business person, and you got burned. You know, it's kind of like.
And I got to tell you, Barry. I mean, many years ago, I had my real estate license as well with Sutton Group, and I belonged to a church as well, and that's a lazy realtor. I got to tell you, you got to expand your client base outside of your own church. An individual should not have to rely on church congregants, you know, to be your sole clients, really.
Yeah, and you know, it was interesting when we were up at the Supreme Court, the lawyer for the church basically said, look, as a church, we don't even encourage folks to make church the basis of your business, just like you mentioned. And so what the struggle here is why would the courts want to get involved in this internal dispute? It's kind of like, on the also just on the business side of things, it's kind of like I make mention in something I recently wrote that, you know, if you are involved in a relationship, an ex-relationship, you're married, you're divorced, you can't expect your ex-spouse's family to continue to do business with you. You know, it's that kind of thing. But why would the courts even be involved in this? And I think part of it has to do with that the courts want to fix things. I mean, they want to bring about peace when there's conflict, and so it seems like it's a natural thing to want to be involved. But the problem with that is that if the court expands too much, it's simply only going to be bogged down with a lot of disputes. When we were up in the court last week, at the Supreme Court, I mentioned to the court that, look, I mean, does the court really want this? I mean, do you want to get involved in disputes as to whether or not God is, or what is the Trinitarian nature of God? It's endless as to where this could go.
Now, if the Supreme Court of Canada was to agree with the lower courts, how would this really impact churches or religious organizations that would discipline their congregation?
Well, I think it would. Well, here's how I see it would happen, or the problem here is that you'd have situations where local churches say they would be second guessing themselves if they were to discipline a church member. Then in the back of their mind are thinking, well, this church member could go to the secular court and we would be asked to then explain ourselves as to whether we gave a proper hearing, whether or not the person knew in advance what it was that the church was looking at, whether or not there was an impartial tribunal that met, all of the rules of what we call in law, natural justice. And so what that would do is that would create a chilling effect within the local congregation. And I think there would be a real sense of whether or not we should even discipline our members. And I think that's an unnecessary interference in the affairs of a local church that really the courts have no business being involved.
So let me ask you this. Would it force the Catholic Church to now allow divorced or remarried couples to receive communion?
First of all, I'd be very, very surprised that the Supreme Court would ever go to this. And so we're talking hypothetical, right?
Right.
So, hypothetically, we could say that if, for example, courts are of... Now, there's a couple of matters here. One is that the court... How do I describe? The court was looking at solely on procedure. So, in other words, as I mentioned, whether or not you have natural justice. So the courts are saying, well, we're not going to interfere into the substantive matter, but we're only just going to deal with the procedural matters. So the problem is it a big step? Is it a giant step to say, okay, well, we're looking at your procedure, but now let's have a little peek in the substantive matter that you're discussing. I don't think the courts were going that far, but the potential is there, I should say, and for that kind of thing. And I honestly, like apparently in Great Britain, the courts, the law there is such that there is this judicial review of the procedure of internal workings of churches. Now, what was interesting was that the Supreme Court asked Mr. Wald's counsel whether or not he wanted the Canadian law to be changed to basically meet what's happening in Britain. And he said, yes, that's what he would like the courts here in Canada to do, the Supreme Court. And Justice Abella looked at him and said, well, good luck on that one, basically. So she was so I really got the sense that she wasn't really interested in that. And from the questions from the judges during the hearing, I got the sense that the court is not interested in digging that far into the affairs of the religious community.
Now, another government bill, Bill C-51, involves faith groups. The purpose of the bill was to remove the so-called zombie laws, outdated and irrelevant for today. And Section 176 is an old law that made it a crime to be violent towards religious officials or to disrupt a religious service. The feds want to remove that. Apparently encountered some serious negative feedback from the religious community. Yes,
and I tell you, we were among those who were giving negative feedback to government on this. We worked with Derek Ross at Christian Legal Fellowship, and we put together a brief that we submitted to the Standing Committee on Justice and Human Rights. This was a very interesting situation because, on the one hand, the government was saying, look, we want to clean up the criminal law. No problem. But this particular section has been in the criminal code since the very beginning of us having a criminal code in Canada. And as you mentioned, it was making it a crime to interfere with a religious official, interfere with a worship service, and so on, or to make a noise outside of the religious service so that it would drown out and try to prevent the religious service from going ahead. And those were the kinds of tactics that would have happened in the past when, for example, you had a lot of new religious groups come into Canada back, when Canada became a country, groups like the Salvation Army, for example. And you'd have the members of the mainstream groups saying, look, this is a strange group, sect, and so on, and we don't want them here. Now, government was saying, well, we no longer need this because if there is any kind of hassle, there's other provisions in the criminal code that we could use to charge individuals who were disturbing religious services. But then that didn't really make a whole lot of sense because there were a lot of other redundant type of provisions in the code. Various forms of assault kind of bleed into one another. There's even just the hate crimes concept. You didn't really need hate crimes. You could have used other provisions. And then towards the end of the debate, as it was going on, the Justice Minister, she made mention of the fact that, well, this really refers to Christians and it's narrow. And we were like, well, if it refers to Christians and the section says nothing about Christians, it does use the term clergy. But so some would say, well, that's really a Christian concept and so on. But okay, even if we were to accept that, then it was very simple to correct it, amend it. That's it, just amend it. And so that's what we were recommending. And ultimately, at the end of the day, I think the members of Parliament recognize that, look, if it's not broken, why try to fix it on this one? And so they ultimately decided that they would keep it and they would amend it. And I should also say that this decision was made after the massacre that happened down in Texas, which was just absolutely brutal, where this individual went into the church and shot up those dear people. And I think at the end of the day, the government said, look, you know what, we're living in a very contentious society on these matters, and it certainly doesn't look good politically to take out this section.
So 176 still has to go before the Senate to receive royal assent. Do you anticipate any more changes then? What kind of changes?
Well, we haven't heard what the government's ultimate position is after the committee's decision on this. Normally, government will just accept the committee's decision and it will work its way through the process. We don't know yet if there will be any last-minute tinkering, but I mean, my suspicion would be that everything will just go on through and they will just leave well enough alone. And my sense is that as a religious community, our willingness to speak up and be counted on this one, I think, has paid a very positive dividend in the end.
Sometimes the status quo is a good thing.
It sure is on this one.
Barry
sure.
Bussey, the Director of Legal Affairs for the Canadian Council of Christian Charities, thanks so much for joining us.
It's been my pleasure.
On behalf of all of us here at Bridge City News, I'm Hal Roberts. God bless and have a great night.